The Honorable, the Dean of Faculty of Law of Universitas Hasanuddin, Profesor Dr. Hamzah Halim, SH, MH, MAP. The Honorable Guest Speaker of today's guest lecture, Professor Tim Stephens, BA, LLB, MPhil, PhD, FAAL. The Honorable Vice Deans, Head of Departments, Head of Study Programs, and also Lecturers of Law Faculty of Universitas Hasanuddin. And also all of the participants who have attended today's guest lecture. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, and good morning to all of us. Welcome to the guest lecture with the theme of General Topic of International Litigation Options in Relation to Marine Environmental Issues in the Asia Pacific, conducted by Faculty of Law, Universitas Hasanuddin. I'm Nanda Yuniza, will be serving you as your Master of Ceremony. First of all, let us offer praise and gratitude for the presence of God. Because of His mercy and blessing, we are able to attend today's guest lecture with a good and well conditions. Therefore, let us open today's guest lecture by reciting Basmalah. Bismillahirrahmanirrahim. Let's move to our first agenda. Opening remarks by the Dean of Faculty of Law of Universitas Hasanuddin, and also to officially open today's guest lecture to Professor Dr. Hamzah Halim, SH, MH, MAP. Time is yours.
Thank you, Master Ceremony. Good morning in Indonesia and good afternoon in Sydney, Professor Stephen. The Honorable, our guest lecturer, Professor Tim Stephens, the Honorable Vice Dean of the Faculty of Law, Professor of the Faculty of Law, all academic staff of the Faculty of Law, and our students. I am honored to welcome you all to this guest lecture. Today, the Faculty of Law is privileged to have with us as distinguished scholar, Professor Tim Stephens from the University of Sydney, Australia. Prof. Tim Stephens, welcome to the Faculty of Law, Hasanuddin University, Makassar. We hope that Prof. Tim Stephens can still feel our warm welcome, even though it is by Zoom application. Prof. Tim Stephens is a renowned expert in the field of international litigation, particularly in relation to marine environmental issues. His extensive knowledge and experience have made significant contributions to our understanding of these complex issues, especially in the South Pacific region. The topic of today's lecture, International Litigation Options in Relation to Marine Environmental Issues in the South Pacific, is of great relevance and importance. The South Pacific is a region rich in biodiversity, but it is also facing numerous environmental challenges. The need for effective legal mechanism to address these issues is more urgent than ever. We look forward to an enlightening discussion that will deepen our understanding of these issues and explore potential solutions. We are confident that Prof. Stephens' insights will inspire us all to take action for the protection of our precious marine and environment. Today's guest lecture is a proof to the Faculty of Law's commitment to internationalization by inviting extreme experts from abroad, like Prof. Tim Stephen. We aim to broaden our perspectives and enrich our understanding of global issues. This initiative reflects our dedication to fostering a diverse and inclusive academic environment where knowledge transcends borders. We believe that such interactions will inspire our students and faculty alike, encouraging them to think global and act locally. Thank you for being a part of this journey with us. Once again, I extend a warm welcome to Prof. Tim Stephen and to all of you. Let's make the most of this opportunity to learn and engage in meaningful dialogue. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning and good afternoon in Sydney, Prof. Stephen.
Well, good morning, everyone. Dr. Halim, thank you most kindly for that invitation, introduction. And may I also extend thanks to the Master of Ceremonies there today, also an acknowledgement to other academic colleagues, professors from your own law school. It's great to be with you and with your students. And also, may I acknowledge my own student here at the University of Sydney, who helped arrange today's guest lecture, Mr. Alif Imam Zaki. Alif is a very engaged student in my Law of the Sea classes this semester, and it's been tremendous to have his participation. So yes, good morning, everyone. Terima kasih. It's really wonderful to be here. I've never been to Sulawesi. I have been to other parts of Indonesia, and I hope physically to visit your law school in the not too distant future. If it's okay with you, I will share my presentation on the screen so that students can see it. And please let me know if that is visible or not to you. I hope you can see the PowerPoint presentation.
Crystal clear, Prof.
It's clear, very good. Okay, so in this lecture, I hope to deal with a range of issues arising from marine environmental disputes in our region, in the Asia Pacific and also in the South Pacific. And we are living in a very interesting time when there are lots of potential disputes that can arise. And as the Dean noted in his introduction, we are facing a number of marine environmental challenges. And these environmental challenges have a tendency to create disputes. Whenever you have an environmental problem, particularly a transboundary environmental problem affecting more than one country, there is the potential for a dispute to arise. So if we can think first about the nature of regional marine environmental challenges in the Asia Pacific, this is just a short list of the kinds of things we are now having to deal with. One that I'm sure you're all very well aware of is the issue of plastic debris, marine plastic debris, very large accumulation of marine plastics in the marine environment, most spectacularly in the North Pacific, in the so-called Great Pacific Garbage Patch. And now there's work underway on an international agreement to deal with marine plastic pollution. More generally, we can think of other kinds of marine pollution, including classic examples of marine pollution, such as oil pollution. And this audience may well be aware, although you're quite a bit further north from where this occurred, of the Montara incident, which occurred in the Timor Sea, occurred within Australia's exclusive economic zone and resulted in very large volumes of oil drifting into Indonesian exclusive economic zone and territorial sea areas, giving rise to a dispute that ended up being resolved in the Federal Court of Australia, where Indonesian seaweed farmers were successful in obtaining damages from the international company that was operating this oil rig in Australian waters. That's a really interesting example of using domestic courts, an Australian court in that case, to resolve what's really an international dispute. Another issue of contemporary concern, I know, is the planned release by Japan of, I think, somewhere in the order of 1 million tonnes of nuclear wastewater from the Fukushima nuclear power plant in Japan. Now, that's raising a lot of concern regionally, and it does engage some of the obligations under the Law of the Sea Convention, to which I'm going to turn in a moment, because if that release has a risk of causing transboundary harm, then an argument could be made that Japan is in breach of the convention. I'll try and get into some more detail momentarily in relation to that, but the fundamental difficulty, I think, in making a case in relation to this planned release of wastewater is that the evidence, so far as it's been presented so far, is not strong enough to demonstrate actual transboundary harm, which would give rise to a violation of obligations under the Law of the Sea Convention. Another regional challenge, an ongoing one, is damage to marine ecosystems. And this is occurring as a result of a number of different kinds of activities. One that I'm going to say something more about in this presentation, it arises from things like artificial island construction, most spectacularly the artificial island construction going on in the South China Sea, primarily as a result of activities by the People's Republic of China. And finally, in terms of regional and marine environmental challenges, let's not overlook the challenge of overfishing. That's a persistent problem that needs to be addressed, and it intersects with other environmental problems. You can't deal with overfishing solely by regulating fishing alone. In terms of dealing with sustainability of fisheries, you also must consider issues such as marine pollution. So they're regional challenges. Let's now move on to think about some of the global challenges to the marine ecosystem that are also having regional impacts in the Asia-Pacific, in the waters of Indonesia, Australia, and many other countries in the region. In fact, all countries in the region. And the two major global challenges are climate change and ocean acidification. Now, these two phenomena are closely linked. So climate change is caused by the emission from human activities of greenhouse gases, primarily carbon dioxide, but also other greenhouse gases. Now, that climate change is warming the atmosphere, but it's also transforming the oceans, because the oceans absorb about 30% of carbon dioxide, and they also absorb most of the heat that's added to the atmosphere through our fossil fuel emissions. So that means the oceans are changing very rapidly, and we are seeing phenomena such as marine heat waves, very hot waters, extraordinarily warm waters. Recently, there have been marine heat waves in places like Florida in the United States, where the water is actually too warm even to swim in. And I know, coming from a tropical country like Indonesia, you're very familiar with warm water. but in this particular part of the United States, apparently it's of incredible and dangerous warmth. Now, when you heat the marine ecosystem, that obviously has impacts on marine species. It also has impacts on the productivity and the general environment of that marine ecosystem and can lead to things like algal blooms, which can be quite dangerous and can also lead to species moving to cooler waters. Now, the related phenomenon connected with climate change, but every bit as serious as climate change, is ocean acidification. Now, ocean acidification refers to how the oceans are changing because they are absorbing carbon dioxide. Now, we may well have chemistry students in this lecture theatre who will know the chemistry of this much better than me and many others. The chemistry is relatively straightforward. When carbon dioxide reacts with water, H2O, it can form hydrogen ions, which have the effect of damaging something called calcium carbonate, CaCO3, calcium carbonate. And this chalky substance is basically essential for the ocean food chain. It's essential for plankton. It's essential for all shell-forming organisms. It's essential for coral reefs. And unfortunately, because the oceans are acidifying, calcium carbonate is now less available than it used to be. And this could is transforming the ocean. So we obviously have to get these challenges under control as quickly as we can. And one of the themes I hope to deal with in this presentation is how we can do that in part under the Law of the Sea Convention. Not exclusively, because the Law of the Sea Convention is ultimately about the world's oceans, not just about climate change, but nonetheless, it is one part of the broader picture of dealing with this global challenge. To underscore just how serious the global challenge of climate change is, I've pulled up this recent chart produced by the Japanese Meteorological Agency, which shows you how much heat the oceans are absorbing. And it shows you that the absorption of ocean heat has risen extraordinarily since the 1950s and is showing no sign of abating, and frankly won't until we phase out fossil fuel emissions. Now, that is leading to these ocean hotspots. Now, if you look at this map, you can see it shows areas where there's been a substantial change in ocean heat content between 1993 and today, roughly 2022. And so the orange areas, and particularly the red areas, show you great areas of warmth. And I think it's interesting to note that Indonesia, most of Indonesia, has sustained a fair bit of additional ocean warmth. And look at Australia, the southeast of Australia. This is very much a hotspot. And I'm sorry to say, because of the warming of the waters in the southeast of Australia, it's damaging kelp, which are basically a form of seaweed, which are really important to the marine ecosystem. So marine heat waves, which is what we call them, are becoming an increasing phenomenon. Now, I thought you might like to be given a reference to a paper that was published just yesterday on the 13th of September in a journal called Science Advances, which looks at something called the planetary boundaries. And this framework is basically a health check for the globe, the global environment, and the extent to which we are living in a safe global environment. And these scientists have come up with this planetary boundaries idea, and they've identified 9 planetary boundaries, and they have identified where a safe operating space, as they call it, might be. And I'm sorry to say, unfortunately, when it comes to most of these planetary boundaries, whether that's climate change, whether that's changing land systems, so the extent of farming and so on, whether that's dealing with biological diversity, we are in a fair bit of trouble. However, one little bit of good news, when it comes to ocean acidification, we are still in the green zone, and we want to stay there. It's very important that we try and stay there, and that just underscores the need for global action. So let's move from these global challenges now to look at the relevant law that applies to deal with marine environmental issues. Now, the framework is a very extensive one now. It used to be a relatively limited one, but it has expanded quite remarkably in the last 40 years. The most important part of the framework is the 1982 United Nations Convention on the Law of the Sea. Now, the UN Convention on the Law of the Sea was adopted in 1992, and it has gone on to become effectively a universal treaty. Almost all states are parties, with a few notable exceptions. Now, the UN Convention on the Law of the Sea has been supplemented by additional implementing agreements that have fleshed out, have given more detail to the Convention on certain topics. These additional implementing agreements include the 1994 Agreement on the Deep Seabed, the 1995 Agreement on Fish Stocks, and most recently, and really quite spectacularly, the 2023 High Seas Treaty. That's what we are calling it for short. Its long title is Agreement on the Conservation and Sustainable Use of Marine Biological Diversity of Areas Beyond National Jurisdiction. The photograph that I've got on the slide shows you the negotiating room in New York at the United Nations, where this High Seas Treaty was recently concluded. And right in the center of that photograph is Ms. Rina Lee, the Singaporean ambassador, who chaired that negotiation and successfully brought it to a conclusion. This High Seas Treaty will be open for signature, I believe. I think it's on the 23rd of September. And I'm sure Indonesia and other states will be looking closely at signing and then ratifying that agreement. It's a very significant addition to the international legal framework for marine environmental protection because it deals with a big gap, namely the high seas. Until this treaty was concluded, we did not have really any detailed rules for protecting the marine environment on the high seas. And now with this treaty, we will have that. We now need to, I think, move on to examine to what extent UNCLOS and other implementing agreements under the UN Convention on the Law of the Sea have been taken up in our region. And one way of looking at this is to look at different regional organizations and the membership of them and whether or not they have ratified the relevant agreements. So let's look first at the Association of Southeast Asian Nations, ASEAN, and I'm sure you're all familiar with ASEAN, a very important regional organization. And if you look at the ratifications, and I checked these again yesterday, it's quite interesting how all ASEAN members, with the exception of Cambodia, have ratified UNCLOS. Timor-Leste, which may become a member of ASEAN soon. I know ASEAN members have given in-principle support to Timor-Leste joining ASEAN, so it's likely to happen soon. So that's very strong support in the ASEAN region for the UN Convention on the Law of the Sea. And I would note, even Cambodia, although it has not joined the UN Convention on the Law of the Sea, it has joined the Fish Stocks Agreement a few years ago in March 2020. So that means that we have a very high level of support in our area, whether it's Indonesia, the Philippines, for the UN Convention on the Law of the Sea, and an acceptance of the value of that convention for dealing with law of the sea issues generally, but also marine environmental issues specifically. Let's look at some other regional organisations and the extent to which they have signed on to the UN Convention on the Law of the Sea. The Asia Pacific Economic Cooperation Organization, APEC. Most APEC members are parties to UNCLOS. The exception, obviously, is the United States. The same goes for the Pacific Community, known as the SPC. All but one of the members of the Pacific Community are parties to UNCLOS. And then finally, what about the Pacific Islands Forum, the PIF? And this is an image of the Pacific Island Forum members, the foreign ministers from those members. All PIF states are parties to UNCLOS. Okay, so what we need to take away from that brief assessment is that there is a strong level of support for the international legal framework for the law of the sea in the Asia Pacific. Very, very strong support. And that means there's also strong support for the marine environmental protection obligations, which are part of that framework. And now I think we need to deal with the content of some of those obligations. And in doing so, we need to look first at Part 12 of the UN Convention on the Law of the Sea. Now, Part 12 is, in a way, almost a treaty in itself. It's a very detailed set of obligations dealing with marine environmental protection. And I want to focus on several of these obligations. First, in Article 192, there is this general statement that states have an obligation to protect and preserve the marine environment. Now, that is quite a general statement, but as we'll see in a moment, that general statement has been given a lot of detailed meaning thanks to dispute settlement mechanisms, thanks to litigation. And that illustrates one of the benefits of using a dispute settlement system. And I'll come back and explain that in some detail in a moment. So in addition to Article 192, this general obligation, you then can look through other provisions of Part 12 which provide more detailed guidance as to how states should meet this general obligation. So let's look then at Article 194. Article 194, paragraph 1, provides that states must take action either individually or collectively to prevent, reduce, and control pollution of the marine environment. And accompanying that obligation is an obligation in Article 194, paragraph 2, which says that states must take measures to ensure that activities under their control do not cause damage by pollution to other states and their environment, or indeed damage the marine environment beyond national jurisdiction. Now, that obligation in Article 194(2) is an obligation to prevent transboundary harm and deals with a situation like the Montara oil spill that I mentioned earlier. Now, when we look at the UN Convention on the Law of the Sea, it's important to understand that it is often described as the constitution for the oceans. You know, so a bit like, say, the Indonesian constitution or Australia's constitution. We know how constitutions work. They don't deal in detail with every single legal issue that's relevant under domestic law, but they do provide the basic or fundamental rules that underscore the operation of that regime. And it's the same for the UN Convention on the Law of the Sea. So it provides a framework which then can be filled in. You know, a bit like the framework of a house, it can be filled in with lots of bricks and masonry and whatever it may be to provide more detail. And that's what's happened with the Law of the Sea Convention, with literally dozens of treaties that provide more detail on environmental protection issues, such as, for instance, pollution from ships. We have extremely detailed rules in relation to that. The next point I want to make, though, is important, and that is that not only does the Law of the Sea Convention refer to rules of international law found in other treaties connected with the law of the sea. That might include treaties dealing with vessel source pollution. But I would also argue that it is relevant to look at the connection between UNCLOS and other treaties, including treaties that don't have a marine environmental focus or a marine focus at all. It's important to understand there can be connections, and some of those connections are being explored as we speak in the International Tribunal for the Law of the Sea, which is currently having public hearings in the advisory proceedings on climate change happening in the tribunal in Hamburg in Germany. And I will say something about that case in a moment. Okay, so let's move on then to see how some of these obligations have begun to be examined in dispute settlement bodies. I'm going to go through some of these disputes in some detail, but I thought just at this stage it's helpful to see some quotes from several disputes resolved under the Law of the Sea Convention that have taken the obligations in Part 12 and explored and explained what they do. So, for instance, in the South China Sea case, the South China Sea arbitration, in that case, the tribunal noted that the environmental protection obligations in Part 12 apply to all states with respect to the marine environment and apply in all marine areas, whether it's the territorial sea or the exclusive economic zone or the high seas. And the tribunal said that as part of a process of emphasizing the irrelevance of sovereignty considerations. So what this is really saying is we need to accept or understand the general application of this marine protection obligations applies to all states in all marine areas. The second observation I think is important to note and arose from a case not from our region, but in the Chagos Marine Protected Area arbitration, where the tribunal noted that the obligation in Article 194 in relation to protecting the marine environment from pollution extends not just to dealing with pollution, but is also concerned with measures relating to the conservation and preservation of ecosystems. And that's important because that therefore connects pollution prevention with broader issues around safeguarding a marine environment. And finally, note this observation made by the International Tribunal for the Law of the Sea in a case called the Seabed Mining Advisory Opinion in 2011, where the court or the tribunal noted that the obligation relating to preventing transboundary harm is a due diligence obligation. So it's an obligation requiring states to take all reasonable measures to prevent pollution of the marine environment that might damage other states. So hopefully what you see from these few quotations is that the dispute settlement bodies have taken the text of the convention and have given it life, have given it more meaning. And that's really been vital to giving the convention more effectiveness, in my view. It hasn't stayed still, it has been developed. So let's look now at how some of these disputes arise. Let's look at, as the Dean noted in his introductory remarks in explaining the topic I'm going to address, let's look at litigation options. So when it comes to the marine environment and marine environmental disputes, countries have a variety of different forums that they can turn to have their disputes resolved. And if you look at the Law of the Sea Convention first, you'll see that Part 15 of that convention establishes a very sophisticated and what we would call compulsory, that is to say, it applies automatically and can't be escaped from, a system of dispute settlement over most disputes arising under the convention, including marine environmental disputes. So if a marine environmental dispute arises under UNCLOS, it can be taken to a tribunal. Now, the next question is, which tribunal? What forum? Where can you go? And this is a really interesting aspect of the convention. The convention gives flexibility to countries. It says, okay, disputes must be resolved, but we're going to give to countries a choice as to where they might like to go. They might want to go to arbitration. They might want to go to a court, whether that's the International Court of Justice or the International Tribunal for the Law of the Sea, or they might wish to go to conciliation. So there's lots of different options. Where there are few options, however, is where states may wish to try to opt out of jurisdiction. Generally speaking, states cannot opt out from the jurisdiction of dispute settlement bodies under UNCLOS, with just a very limited number of exceptions, such as in relation to maritime boundary delimitation or military activities. And the final point I'll just make here is that in addition to Part 15 creating a system whereby states can litigate marine environmental disputes between themselves, it also sets up a system whereby international organizations can go to the International Tribunal for the Law of the Sea to seek an advisory opinion on a question relating to the Law of the Sea Convention. And that advisory jurisdiction has proved to be a really important way of dealing with essentially marine environmental disputes. So that's the UN Convention on the Law of the Sea. Sitting beside the UN Convention on the Law of the Sea is the general system of dispute settlement under international law, which I'm sure many of you are familiar with. And obviously, central to that system is the International Court of Justice, the principal judicial organ of the United Nations. Now, the ICJ has jurisdiction or can assume jurisdiction through a variety of different ways. It can take on cases via a treaty, including the UN Convention on the Law of the Sea. It can take on cases via a special treaty referring the specific case to the court. That kind of treaty we call a compromis. Or finally, it can have jurisdiction where states have deposited what are called optional clause declarations with the International Court of Justice, accepting as compulsory the jurisdiction of the court in relation to all disputes or a limited category of disputes. Now, there are 74 countries that have submitted optional clause declarations. Only, however, only exactly 7 Asia-Pacific states have accepted the jurisdiction under the optional clause. So that's a relatively small number in comparison, say, with Europe. Now, the final point to say in relation to the International Court of Justice is not only can it decide disputes between states, it also has this advisory jurisdiction. It can issue advisory opinions on issues of international law when requested to do so by an authorised United Nations body, and it has done so in a number of important respects. So let's look at the ICJ and the extent to which it has dealt with marine, environmental and resource disputes in our region in the Asia-Pacific. And here I'm taking quite a broad definition of marine, environmental and resource disputes to try and capture the range of cases that we have seen. The very first case in the International Court of Justice to involve some kind of marine environmental issue in our region was the nuclear test cases between Australia and New Zealand on the one hand and France on the other, and that related to French atmospheric nuclear testing in the South Pacific that impacted not only on the small coral atolls where France was detonating nuclear weapons or nuclear devices, but that had a very significant impact on the marine environment as well. And Australia and New Zealand litigated that case against France. They were unsuccessful in most respects because the court never issued a judgment on the merits. However, you could say that the litigation was part of a broader strategy that was successful because France ultimately ceased its nuclear testing program in the South Pacific. Now, the court never dealt with the marine environmental issues, but they were raised in some of the submissions of the parties by Australia and New Zealand. Moving then on to the East Timor case between Portugal and Australia, which you may be aware of. Now, that case did not involve any marine environmental issues, but it did involve marine resource issues, and often they are quite connected with marine environmental issues. So that's why I'm including it in this list. Now, in that case, Portugal unsuccessfully challenged a treaty called the Timor Gap Treaty, which was between Australia and Indonesia, relating to the resources of the Timor Sea. Now, Portugal was unsuccessful. I'm sure some of you have studied this case in your classes. Was unsuccessful because Indonesia was not present in the proceedings, and the court found that Indonesia was an indispensable third party, and because Indonesia had not consented to the jurisdiction of the court could not proceed. Then let's move forward a number of years to these two sovereignty disputes. So the sovereignty case over Pulau Ligitan and Pulau Sipadan, a case between Indonesia and Malaysia. Now, that case was primarily a case about sovereignty over two very small islands near the coast of Borneo. Now, ultimately, the International Court of Justice preferred Malaysia's claim to sovereignty over Indonesia. Now, the case did not deal with marine environmental issues in any detail, but I think nonetheless it's interesting that Malaysia, in its argument, referred to some of its sovereign activities as including the establishment of a bird sanctuary and control over turtle conservation on Sipadan, and also fisheries licensing as part of its evidence as to why it had sovereignty. So there was at least some marine environmental flavour, albeit very small, to that dispute. Another case involving sovereignty over maritime features was the sovereignty over Pedra Branca case between Malaysia and Singapore. Some similarities with the Pulau Litigation case. That also did not have any significant or major marine environmental issues. However, if you read the judgment, you'll see that the court did refer to Malaysia's concerns relating to environmental impacts that might result from Singapore's plans to reclaim areas around these features. Let's now move on to two cases which did have much more substantive connections with marine environmental issues. First, the whaling in the Antarctic case. Now, this was a very substantial case in the International Court of Justice between Australia and Japan, with New Zealand intervening. Now, there's lots of interesting features about this case, but at its core, it very much was a case about marine environmental protection in relation to whales, cetaceans, the great whales. Now, in that case, Australia successfully argued that Japan was in breach of its obligations under the International Convention for the Regulation of Whaling, because Australia argued, and the court accepted, Japan's whaling program was not for purposes of scientific research as required by the Whaling Convention. Now, a couple of important points to note about this whaling case. It decided actually only a very narrow set of issues. It did not consider broad-ranging environmental questions. And that illustrates just how litigation tends to be focused on key issues rather than broader concepts or disputes. And I'm sure this is the case in relation to litigation in the Indonesian domestic legal system. The court is concerned with resolving the narrow set of issues at hand rather than making a general pronouncement on a range of issues. The final case that I'll mention in relation to the ICJ is the Marshall Islands nuclear case. Now, this case ended up being unsuccessful, but the Marshall Islands, which is in our region, sued several governments, arguing that they were in breach of their nuclear non-proliferation obligations. And the Marshall Islands pointed to the environmental impacts of nuclear testing that occurred on the Marshall Islands and how that also involved damage to the marine environment around the Marshall Islands. Now, there are some parallels between this case and the nuclear test cases in the 1970s, in that the court, in this case, also decided not to address the merits, finding that in this particular case, there was in fact no dispute, no real controversy between the parties, and so the court did not have jurisdiction. So what can we say, summing up some observations around that litigation in the International Court on marine environmental issues? It's important to note that in most of these cases, marine environmental or natural resource issues have not been the central concern. It's been part of the litigation, but not the central part. The other observation to note is that none of the International Court of Justice cases have considered marine environmental protection obligations under the UN Convention on the Law of the Sea. The only case that comes close to looking at law of the sea environmental protection obligations is really the nuclear test cases, which took place before the UN Convention on the Law of the Sea, but nonetheless did deal with some customary law points that gave or were relevant to the emergence of the convention. So, for instance, New Zealand argued and Australia argued that France's nuclear testing infringed high seas freedoms. Now, those arguments, as I mentioned before, were never fully tested because the court never decided the case. So can I just really emphasize once again that when you're looking at international litigation, there is a strong tendency, an extremely strong tendency, for the court to want to decide a case on the basis of narrowly defined issues. And to illustrate that, have a look at the whaling in the Antarctic case. Now, in that case, the court was only concerned to consider whether Japan was in breach of the International Convention for the Regulation of Whaling. The court did not consider the Convention on Biological Diversity. It did not consider the Convention on the International Trade of Endangered Species of Flora and Fauna, CITES, nor did the court consider the UN Convention on the Law of the Sea. Now, all of those conventions were, in my view, relevant in some way to the dispute. But the way that the parties argued the case, including the applicant, Australia, was to make it a very narrow case, because the experience in litigation is that you're more likely to win if you argue some narrow points well than if you argue broad points well or badly. You're best off focusing on narrow points. Can we also now just finish with an observation in this section about the implication of this kind of litigation in the International Court of Justice? I think it's fair to say that the International Court of Justice has made a significant contribution to some aspects of the law relating to environmental protection, including marine environmental protection. And that's, I think, in my view, because in the whaling in the Antarctic case, the court was very happy to accept jurisdiction over the dispute without requiring Australia to satisfy any demanding requirements of standing. So when we think about standing, rights of standing, what we are thinking about is the entitlement of a litigant to litigate a case. And I'm sure in your legal studies, you've thought about issues of standing. And usually, an applicant before a court will only have standing if that applicant has a defined legal interest in a case. You can't sue in relation to a land case that might arise, say, on the island of Java, if you don't have property there, if you don't have any connection there. You have to have some kind of interest. Now, in the whaling in the Antarctic case, the court was happy to accept, and it didn't really look at the issue or need to explain it. The court said any party can sue any other party under the Whaling Convention without having to demonstrate any special interest. And that's really important, because what that says is that when it comes to a treaty that concerns the marine environment or any other global interest, the court is happy to allow any state to have standing. And that means that any state can uphold the regime. So I think that's actually a really important outcome of that case. Can we move now from the International Court of Justice to look at the UN Convention on the Law of the Sea and the disputes that have arisen under the convention in the Asia Pacific and how they've been resolved. Now, it's actually a very substantial list. I'm sure, given the time, I'm not going to be able to go through all of these disputes in any detail, but let me just give you some kind of flavour for these disputes and what they have involved. So the very first one was the southern bluefin tuna case between Australia and New Zealand against Japan, and that case related to a Japanese experimental fishing program for southern bluefin tuna. Indonesia, by the way, is a party to the Convention for the Conservation of Southern Bluefin Tuna, which was at the heart of this dispute. Now, that case was never successfully resolved by arbitration for jurisdictional reasons, and ultimately it had to be resolved in the Commission itself. And what that says is that the interaction between the UN Convention on the Law of the Sea and other treaties, such as fisheries treaties, is not always straightforward, and problems can arise, including in this case. Another case, the next one, was the Volga case between Russia and Australia. This was one of a number of cases where countries, in this case Australia, arrested a fishing vessel for illegal fishing, and where the International Tribunal for the Law of the Sea had to consider whether Australia had lawfully arrested the vessel and whether it should be released. Now, there have been quite a number of these cases. Some other ones down here include the Hoshin Maru case and the Tomi Maru case between Japan and Russia. They also involved the arrest of fishing vessels, and they make up a very substantial proportion of the caseload in this body, the International Tribunal for the Law of the Sea. It has, I think it's fair to say, in summary, primary jurisdiction when it comes to the arrest of vessels in relation to fisheries matters. And can we just connect this to environmental issues? Fisheries issues are environmental protection issues because they relate to the marine ecosystem, and the tribunal has emphasised that in several cases. Another case that's very interesting is the Straits of Johor case between Malaysia and Singapore, relating to Singapore's land reclamation activities in Malaysia. As many of you will know, Singapore is a very small country, and it has sought to expand its territory by very aggressive land reclamation. Now, that has had environmental impacts, and in the Straits of Johor case, Malaysia challenged Singapore and argued that Singapore was in breach of the convention. The International Tribunal for the Law of the Sea ordered Singapore to stop land reclamation pending the merits of the case. And what ultimately happened is that the parties agreed a solution between themselves, so the case never went to the merits. Now, just finally, in relation to the International Tribunal for the Law of the Sea, and perhaps I haven't made this clear and I should do so now, ITLOS, this body was created by the UN Convention on the Law of the Sea. It is a permanent court, permanent tribunal that sits in Germany in Hamburg, and it has now resolved a number of important contentious disputes on marine environmental issues between countries. And it has also been engaged in providing advisory opinions on marine environmental issues. And there have been two of these advisory proceedings to date. One in 2011, a case relating to deep seabed mining. And I've included it here as an Asia-Pacific case because effectively it was prompted by Nauru and Tonga, two states in the Asia-Pacific. And effectively they were seeking advice from ITLOS as to what obligations states are under to protect the marine environment when they engage in deep seabed mining beyond national jurisdiction. The final advisory, or the second advisory proceedings I'll refer to are these, the climate change advisory opinion proceedings happening right now. You could go online and probably see footage of the proceedings later today. So wait until the Europeans wake up and those proceedings are in Hamburg. Now, I said before, when dealing with part 15 of the UN Convention on the Law of the Sea, this dispute settlement part, that it gives states a lot of flexibility in terms of which forum they can litigate their case. So they can go to ITLOS if they want, but more frequently, they tend to go to what's known as Annex 7 arbitration. So this is arbitration under the convention. And we've seen a number of these arbitral cases in the Asia Pacific. I've already referred to two of them, Southern Bluefin Tuna, Straits of Johor, which was ultimately settled. But one that wasn't settled and did go to the merits was the South China Sea case, a very significant case. And finally, can I briefly mention this other option, conciliation? If you don't want to go to a tribunal, there's also the option in some circumstances of turning to a softer form of dispute settlement, conciliation, which is what Timor-Leste did in challenging Australia. And that led to a permanent maritime boundary between Timor-Leste and Australia. Okay, I'm just mindful of the time and I want to ensure that people have an opportunity to ask some questions. So I'm just going to move perhaps a little bit more quickly into the substance of some of these disputes. And first, I'm going to look at the South China Sea case. Now, I'm not sure to what extent you've looked at this case in your studies, but it is certainly worth doing so because there's no more, in my view, detailed case on marine environmental protection. This case looks in great detail at evidence of marine environmental harm and applies the obligations under the Law of the Sea Convention. So just a brief reminder as to what this case was about. This case was brought by the Philippines against China in relation to a number of Chinese activities in the Philippines exclusive economic zone and in and around contested areas between the Philippines and China. Now, I'm going to focus in my remarks on the marine environmental protection issues and not on the broader sovereignty issues because it's a very large case. But the Philippines noted that China had engaged in these activities, including interfering with Philippines fishermen. China had basically supported illegal fishing by Chinese-flagged vessels. It had even allowed those Chinese vessels to take endangered species such as turtles, which is what this photograph shows. China had violated the Philippines' traditional fishing rights at a place called Scarborough Shoal. And in addition, the Philippines noted that China, in reclaiming land around some contested features in the South China Sea, was damaging the marine environment. Now, the evidence was actually remarkably clear in this case. It was clear that Chinese fishing vessels had harvested coral, endangered sea turtles, giant clams, and sharks, that China had been using propellers of its vessels to access clams, damaging coral reefs in advance of reclaiming land and constructing artificial islands, effectively. Now, in terms of the tribunal's conclusions on the facts, on the evidence, there's some really important points here to note. The tribunal, in this case, which was under the Law of the Sea Convention, was very happy to consider and apply the Convention on International Trade in Endangered Species, CITES. The tribunal said CITES actually informs how we interpret and apply obligations under UNCLOS to protect and preserve the marine environment. The tribunal said that having regard to the obligations and the evidence, that China was in breach of the convention because it was aware of the environmentally damaging activities and took no steps to control them, and therefore was in breach of Part 12 of the convention. Moving from fishing, the tribunal then looked at the phenomenon of land reclamation, whereby China is transforming some of these natural features in the South China Sea into artificial islands for military purposes. And China is doing this at a remarkable rate. It's not the only country doing it, but it is the country doing most of it. And the tribunal considered what was happening on 7 reefs in the contested Spratly Islands. Now, the evidence, again, was very clear here. And it's clear from satellite imagery. If you see the pictures on the slide there, that shows one particular reef known as Fiery Cross Reef. And in the course of just 3 years, a bit over 3 years, it was turned from a natural place into an entirely artificial place with devastating impacts on the coral ecosystem. So what did that mean in terms of China's compliance with its marine environmental protection obligations? Well, these are some really important conclusions that the tribunal reached. The tribunal applied Part 12 of the Convention and said the following. First, that China was in breach of Article 192 because it failed to protect and preserve the marine environment. Second, it was in breach of Article 194, Paragraph 1, because it polluted the marine environment. Third, China was in breach of Article 194, Paragraph 5, because it failed to protect fragile ecosystems and the habitat of threatened and endangered species. Now, moving on, the tribunal also said that China had failed to cooperate with the Philippines, which is an obligation under the Law of the Sea Convention when it comes to marine environmental protection, and had also failed to undertake an environmental impact assessment as required by the Convention. So just in summary, and apologies if you've already read the case, but if you haven't already done so, I think it's valuable to do so. Because even though most commentary about the case has been concerned with its implications for maritime claims and zones in the South China Sea, I mean, think of the so-called 9-dash line. That's of great controversy and which the tribunal found that China could not validly assert in the South China Sea. Now, pretty much all commentary has focused on those issues arising out of this case. But if you look at the judgment, the award, I should say, 150 of the 501 pages of the award are actually concerned with fisheries and environmental questions. So that means there's actually a wealth of material there in interpreting and applying Part 12. And we've already seen some of the important conclusions that the tribunal reached. They included this important conclusion that Part 12 applies irrespective of sovereignty disputes. So it's no kind of excuse or defense to a dispute under the convention to say that the areas are under a sovereignty dispute. That's not going to relieve you of your obligations to protect the marine environment. Now, can you see the rationale for that? The reason for that is because the marine environment is a shared environment by all countries, and the convention creates these collective obligations of protection. The other point I will make in conclusion on the South China Sea, have a look at how the tribunal emphasizes the linkage or connection between environmental protection and fisheries management. So what the tribunal is doing here is connecting Part 12 with the other parts of the convention dealing with fisheries. And that's a really important conclusion because it means that when it comes to sustainable fishing management, you're not focused just on the sustainability of a particular stock, but you also must consider the fishery in the broader marine environmental context. So that's the Philippines and China, South China Sea case. Can we now move on to consider current proceedings before the tribunal? And in your studies, if you want to look at these proceedings, I would encourage you to do so, because you will see here a number of countries explaining and exploring the marine environmental protection obligations under the UN Convention on the Law of the Sea, right now in real time. But first, can I give you some background to these proceedings? So the International Tribunal for the Law of the Sea, as I mentioned before, does have the capacity in certain limited circumstances to issue an advisory opinion on a question of the law of the sea. Now, in order for the tribunal to have advisory jurisdiction, it must receive a valid request for an advisory opinion from an international organization that has the capacity to request that. So, a government can't individually request an advisory opinion. It must come through an international organization. And that's what occurred in the deep seabed mining advisory opinion. And it's also what's now occurred in relation to climate change. A few years ago, in 2021, a number of small island countries created this international commission known as COSIS, the Commission of Small Island States on Climate Change and International Law. And the sole purpose of this commission was and is to request an advisory opinion of the tribunal. And that advisory opinion request was made in December of last year. And this is what COSIS has asked ITLOS to answer. ITLOS has been asked, what are the specific obligations or duties under the convention to prevent, reduce, and control pollution of the marine environment in relation to the damaging effects that result from climate change, including through ocean warming and sea level rise and ocean acidification? And the second question is, what are the obligations to protect and preserve the marine environment generally? So we're not talking just about pollution here. What are these general obligations to protect and preserve the marine environment in relation to climate change impacts, including ocean warming, sea level rise, and ocean acidifications? They're very important questions, and countries have been making submissions to the International Tribunal for the Law of the Sea, both written submissions and also now oral submissions in the tribunal. This morning and yesterday, I spent some time going through those submissions and identifying those made by countries in our region, including Indonesia. And this is the list of all the Asia-Pacific states and organizations that have an Asia-Pacific dimension that have made either written or oral statements, or plan to make oral statements before the tribunal. So they include New Zealand, Japan, China, Australia, Indonesia, Nauru, and Micronesia. Vietnam, I've put an asterisk beside Vietnam because Vietnam put its submission in late, so I'm not sure whether it will be considered by the tribunal. Also, COSIS itself, this Commission of Small Island States, also put in a very lengthy statement. And finally, the South Pacific Community, or the Pacific Community as we call it, the SPC. The image on the slide is the Prime Minister of Nauru, who is a co-chair of COSIS. He is making his submission there in the International Tribunal for the Law of the Sea. Now, these submissions are really interesting. I looked at Indonesia's submission this morning and yesterday. And I'm not going to be able to, given the time, because I know we want to save about half an hour for questions if possible. I thought I might focus in particular on the statement by the Commission to the tribunal and what the Commission is seeking to do, and in fact what all governments and other entities making submissions before the tribunal are seeking to do are to get the tribunal to explain how Part 12 applies or doesn't apply to climate change. To what extent do the obligations in Part 12 in Article 192 and Article 194, to what extent do they pick up obligations to address climate change, knowing that we can only protect the marine environment by combating climate change? And the Commission, in a very long statement, this is from paragraph 425, the Commission makes this point, that the specific obligations in Part 12 mean that states must take all necessary measures, including adopting legislative and regulatory measures aimed at reducing greenhouse gas emissions from all sources and limiting average global temperature rise to 1.5 degrees Celsius above pre-industrial levels. In summary, what the Commission is arguing is that states, in meeting their obligations under the Law of the Sea Convention, must cut greenhouse gas emissions. It's not enough to say that that issue is solely dealt with by the Paris Agreement on Climate Change or the United Nations Framework Convention on the Law of the Sea. The Framework Convention on Climate Change, the UNFCCC. Those agreements are relevant, of course, but they inform the obligations under the convention, which could well be stricter than the obligations under those other regimes. So it's worthwhile watching how this dispute, which is effectively a dispute, even though it's an advisory case, you'll see if you read the submissions that governments are taking different views. Indonesia takes a different view from, say, Vietnam on some of these issues. So just finally, and I'm trying to finish at 1:30 local time, because then hopefully that will leave some time for questions. Just finally, can I make some observations that will hopefully bring some of the themes together? I've now been researching and teaching in this area for about 20 years. And I remember when I began researching this area, people would say things like, states in the Asia-Pacific will never resolve their environmental or other disputes through dispute settlement mechanisms. People would say things like, that's just not the ASEAN way of doing things, that in this region people prefer consensual, non-confrontational mechanisms of dispute settlement. But what we've actually seen is that is a myth. It is a myth that countries in our region don't want to use dispute settlement mechanisms. We're seeing countries, increasingly sophisticated countries, seeing the value of using dispute settlement mechanisms. So the reality is Asia-Pacific states, particularly those in the South Pacific, are very willing to utilize dispute settlement mechanisms to deal with marine, environmental, and other environmental disputes, and indeed disputes generally. And there's a very good article by Tommy Koh, Ambassador Tommy Koh of Singapore, and How Do I Fan in 2016, where they really explode this myth and say that Asia-Pacific states are quite happy to have their disputes resolved, or increasingly happy to have disputes resolved, and see the benefits from them, from that. The second myth I want to point out is that it's sometimes said that the UN Convention on the Law of the Sea is essentially fixed in time, and that it's a constitution that shouldn't really be further developed. It is what it is and what it was in 1982. But what we're seeing, actually, that is a myth, because the reality is that the dispute settlement system under Part 12 is allowing, the dispute settlement system under Part 15 is allowing the marine environmental protection obligations to be clarified, to be developed, to be given greater effect. And you see that most clearly in a case such as the South China Sea arbitration. So that concludes my remarks. I do hope that presentation was of some use to you, and I would be very pleased to take any questions.
Thank you very much, Prof. Stephen. That was really great presentation. We got a lot of new insights, actually, especially for me, because I'm so interested in environmental issues and law of the sea as well. Before I open the Q&A session, I would like to brief introduce you because in the beginning we didn't introduce you. So Dr. Tim Stephen is a professor of international law at the University of Sydney Law School. He teaches and researches in public international law, with his published work focusing on the international law of the sea, international environmental law, and international dispute settlement. And yeah, he got lots of awards and honors, and especially I see some of our JSAP muters also attending this session, Professor. And I would like to mention your awards and honors. First, from Terry Connolly, friend of the JSAP Award 2021, an Australian Research Council Future Fellow 2015-2019, Stephen McShney-Baum Award to a National Administrator of the JSAP International Law Moot in 2014, and the last one is International Union for the Conservation of Nature Academy of Environmental Law Junior Scholarship Prize 2010. We are so honored to have you here. And is there any question from the floor? We got one, we got two. Oh my God, we got plenty. I wish that I could also have a question for you, sir. Please, the student with the black shirt first.
From here.
Di mana Kak? Ya. Yeah.
Assalamualaikum warahmatullahi wabarakatuh, and thank you for the change. My name is Fadilus Risaputra from Faculty of Law. My question is about the Fukushima nuclear wasting water. Where is it? There is a possibility for nuclear wastewater to go other countries' territory, like even Indonesia. And my question is, what's if nuclear wasting water come to our territory or in the border of our territory, and how did IAEA to give permission to Fukushima, Japan, for drop the nuclear wasting water when we know that was dangerous? Thank you very much.
Could you please mention your name?
My name is Fadilus Risaputra.
Fadil.
Yes.
Okay.
Thank you.
One question from Fadil. Professor, would you like to take the questions first and then we can answer later? Or
Oh,
you
look,
want to answer
I'm
one
happy
by
to
one?
take them one by one. It might be best because they might be quite different. So,
All right.
Fadil, thank you very much for that question. It's a very interesting question, and I'm looking. I could share my screen actually to show you a map of. Maybe I shall do that so you can get a sense of how the nuclear waste will wastewater will. Can you see that on the screen?
Okay.
So there is a suggestion that in Japan releasing the water, it will enter a number of different ocean currents which circulate in the North Pacific Ocean. Now, as I understand it, I stand to be corrected. As I understand it, the water will predominantly remain in the North Pacific and is unlikely to drift further south towards towards, the south part of the Asia Pacific, the Philippines, Indonesia, Australia, and so on. So it's relatively self-contained. So hopefully that allays some of our concerns. But there's another issue I think worthwhile noting, and that is that although this is a case of transboundary harm, in order for a case of transboundary harm to be made out, you do need pretty clear and compelling evidence that harm will result or is likely to result. There has only been one previous case dealing with nuclear waste affecting the marine environment in this way or in a similar way. And that's a case called the MOX plant case between Ireland and the United Kingdom about 20 years ago. And Ireland challenged the United Kingdom's commissioning of a nuclear fuel reprocessing plant in the United Kingdom and argued that there was a risk it would damage the marine environment in the Irish Sea. Now, that case was not successful, and I think the central reason for it was that the evidence was not particularly strong. Now, here, I think the difficulty is the International Atomic Energy Agency has come up with a view which is probably a fairly considered view because they are quite a cautious institution, and it's likely that it's not going to be possible to prove substantial environmental harm. I saw one observation by the IAEA that the level of pollution is likely to be no greater than the current radioactivity of seawater. So seawater is already naturally radioactive, so it shouldn't rise very significantly. And in addition to that, there's also already a lot of water entering the marine environment from nuclear power plants in places like China. China has a number of nuclear power plants. They just in their ordinary operation generate wastewater which carries nuclear radioclides. So yeah, let's hope that it's okay. But I think it's important to note, if it's not okay, then countries, including Indonesia, if it's affected, has every entitlement to commence proceedings in the Law of the Sea Tribunal. And that might be an appropriate way to go if the evidence firms up.
Is that clear, Fadil? Okay, it's clear. Okay, the next question, I got one question in the Zoom meeting. Please, Habaib. You may ask a question.
Thank you very much, and good afternoon, Professor Stephen. It is a huge honor for me to be able to attend your lecture, and I was wondering throughout the presentation where I imagine a scenario where state might file a proceeding against other state to international bodies, for example, the ICJ, because of certain activities like conducted by the state causing marine pollution that could potentially breach international obligation and therefore affecting the ability of the ocean to absorb the carbon dioxide, thereby intensifies the climate change. And given that, to my knowledge, the International Court of Justice have not yet heard any climate cases, my question is, what are the possible challenges and the opportunities, particularly acknowledging that the current progresses states have been requesting for advisory opinion on obligation of states in respects on climate change?
That's a very good question. So you are absolutely correct. So the International Court of Justice has not yet taken on a climate change related case. However, that's changing, and it's changing pretty rapidly because the court or has accepted a request to provide an advisory opinion on the obligations of states in respect of climate change. So we are now in this unique situation where both the International Tribunal for the Law of the Sea and also the International Court of Justice are dealing with climate change issues. Now, I also think it is quite possible, given how quickly some of the climate impacts that we are seeing are unfolding, I think it's quite possible that we will also see a contentious case from one government against another in relation to climate change. Now, typically, it has been said that that kind of case will be difficult for evidentiary reasons, because it's going to be hard for one country to establish that it has suffered harm as a result of the actions of another country, clearly, because of the nature of the climate change problem being a global problem. However, there have been some developments in the science of attribution, is what it's called, which allows scientists to attribute certain climate change related disasters more clearly to the general phenomenon of climate change. And then it can be attributed to certain countries that are making larger contributions to the problem than others. So I think it's possible that we might get it. Now, just in relation to the advisory proceedings in the ICJ, note that that's a relatively limited case. If you look at the question, I'm just looking at the question that's been posed. There's some open-ended aspects to it. But I'm not sure, I must confess, I'm not sure what the court is going to be able to do with the request beyond saying that states need to comply with the Paris Agreement on Climate Change and the UN Framework Convention on Climate Change. Somewhat different kind of case from the ITLOS proceedings, which are very much focused on the obligations under the Law of the Sea Convention.
Is that clear, Habaib?
Yes, I think it is very clear. Thank you so much for the valuable insights, and I also concur upon the opinion where perhaps the advisory opinion on the ICJ, particularly on climate change, might only reiterating the obligation that have been set forth under climate agreements, including Paris Agreement and Glasgow Climate Pact. Thank you so much, Professor.
Thank you, Habaib and Prof. Stephen. Actually, Habaib question is related to my experience. I had a climate change training few weeks ago in August, and we visited this Pari Island in Jakarta. Pari is stingray in Bahasa. So the community in there, they already brought the case to Switzerland court because they are suing Holcim, the cement company, for causing so much CO2, and therefore they are causing climate change, and the climate change are likely to cause sea level rise, and the island is going to sink in the future. And they already experienced this severe flood in the last few years. It was it was really terrible. So the community in there they are accompanied by Walhi, I don't know, WALHI. They brought the case to the court, but we haven't heard any decision yet. So it's very interesting to see, because the community, they didn't want to bring the case to Indonesian court because they are likely to fail. Yep. They said that our court are still, many of our judges are not familiar with the term of climate change and things about that nature. So yeah, that's just a brief of my comment. And I'm going to ask the next question, and the next student, from the top of, on the top of there.
Yes. Okay, thank you so much, moderator, for giving me the chance to ask question. Good afternoon, Mr. Stevens. So, as you have mentioned earlier, that some of the way to approach to solve the problems on marine challenges are arbitration, mediations, and so on. And some of the cases you've mentioned has parties to the case, since there's the applicability of a principle of polluter pays. One case here in Indonesia on the Bintan Island, one case here in the oil pollution phenomenon on that island hasn't been solved for almost 10 years. And it has been investigated that the source of the oil came from the high seas on the Malacca Strait. However, on this case, the state or person responsible regarding this unfortunate event hasn't been found. Thereby, my question is, what approach does Indonesian government has to take to solve this problem? Thank you so much.
Thank you very much for that question. So if I'm correct in my understanding, this oil pollution has somehow drifted from the Malacca Straits. Is the suggestion that it's come from a ship, or are we thinking it's possibly come from an oil platform? If it's coming from a vessel, then actually, this is where we are very fortunate. There is a very highly developed system whereby victims of oil pollution damage can seek damages for any damage that they suffer. And that's thanks to work by the International Maritime Organization primarily, which has concluded a number of treaties dealing with liability for oil pollution damage, and sets up a system effectively of strict liability where any victim of pollution damage can sue in a domestic court against the polluter. Now, in your question, you noted that it's not clear who caused the pollution incident. So it's hard to find the wrongdoer. Well, there's a good response in relation to that as well, in that these treaties actually establish a fund that victims can seek compensation from. So you don't necessarily even have to identify the wrongdoer, the owner or operator of a vessel, say. You can seek a recompense from this oil pollution fund, basically an insurance fund, which is established by shipping companies, or a levy on shipping companies. So yeah, there's a variety of different options. And just coming back to the really important observation made by our MC about the use of domestic courts, my presentation has primarily been about using international forums for dealing with marine environmental issues, but let's not overlook the value of using, wherever possible, domestic courts and tribunals. And there are increasingly these opportunities, whether you are going to the courts of Switzerland or Australia or the United States to deal with marine environmental and other environmental issues in Indonesia or elsewhere. There are lots of different litigation opportunities, and maybe in your legal careers ahead, you'll get to work on some of these interesting cases.
Any further question, Aksan? Okay, so just I would like to know you that Ahsan and Habaib are our JSAP mutters. So I think, yeah, they might be so excited to attend your session. And before we finish the session today, one more question. You still want to have a question? Yeah. One question from student here.
Right. Thank you for the opportunity. I would like to give a question for Professor Stevens. But allow me to introduce my name first. My name is Aulad Muhammad Zulilham from Faculty Law Legal Study Program. My question is that, as we observed in the presentation earlier, there are numerous issues with the marine differential concern. My question pertains to how regional organization in the Asia-Pacific region address these marine environmental issues with the international organization or bodies. Thank you for the chance. I will give it back to the Professor Stevens.
Thank you for that question. That's a really important question. Regional organizations in the Asia Pacific have tended not to be as strong as they are in some other parts of the world. So if you think of maritime regions, say like the Mediterranean or the Persian Gulf, there are a number of examples of relatively well-developed and strong regional organizations with a marine environmental focus that have coordinated among governments to try and protect the marine environment. We don't have anything like that really across the Asia Pacific. We've got some sub-regional examples, particularly in the South Pacific. But I think, your question is very important. And I think an argument could be made that more work should be done, especially through ASEAN. So ASEAN is doing important work. I know that they're doing work on marine plastic debris, for instance. They've come up with a marine plastic debris pollution plan. But yeah, much more work could be done by some of these regional organizations in order to deal with regional challenges. No, you're absolutely correct. And just finally, can I say how nice it is to get questions from the students generally, but particularly from the Jessup Mooters. I've been involved in the Jessup Moot since I participated myself in 1998, and we were fortunate to go to Washington to represent Australia. And it's a wonderful competition. And I do remember we mooted against an Indonesian team in 1998. I now can't remember the law school. It was quite some time ago, but yeah, it's wonderful that so many Indonesian law schools are participating and performing so well in the Jessup. So all the best for it.
Thank you very much, Prof. Stevens. When I got information that you are going to virtually coming to our faculty, I volunteered myself to be the moderator because your topic is just so my topic. I graduated from the University of Queensland back in 2018, and I wrote a thesis on the impact of sea level rise on in what is it? What do you call our country again?
Archipelagos.
Asia Pacific. Yeah.
Oh, yeah.
Oh, sorry. Not Southeast Asia. People in this island countries. Should I forget? Sorry. It's hard.
Just say in Indonesia, Rafika.
Ya, apa namanya? No, olah say. Just
No, say in Indonesia, and then we can see. What's in Indonesia?
yeah. Well, in South Pacific Asian states.
Oh, okay.
Yeah, and I would like also to say hello to Alif, your student there. Alif, yeah, hello Alif, if you're still here, and also Professor Stephen. This is Prof. Maskun.
Yes, thank you.
Our
Nice to meet you.
And
Likewise, very nice to meet you.
prominent
Sorry.
professor in environmental law issues as well.
And also, I did my master degree in New South Wales Uni, Prof. Stephen.
Yeah, neighbor.
Just to inform you. Sorry.
It's very interesting to have our the Australian alumni together in this morning and discussing about similar our focus area in environmental issues. Before I close, Prof. Stevens, I would like to present a certificate for you. Sekali. Yeah, this is and we apologize.
Thank you. That's very kind of you. That's very nice.
Yeah.
Beautiful, beautiful. Thank you.
Okay.
And we apologize from our dean because he has to attend another meeting at uni. And yeah, before we close, maybe we can have a group picture. Khalif, yeah. Please, could you please turn on your camera? Participants in the Zoom, please turn on the camera because we are going to have a group picture. Khalif, gimana, ready? Yeah, yeah. Please turn on the camera because we are going to have a group picture, and please put the biggest smile. Yeah, one. We will give you 5 seconds. Okay, 1, 2, 3, smile. Sudah. Okay, thank you very much. Prof. Stephen, I wish that you can come here, not virtually. Yeah, we can have further discussion.
I would like that.
Yeah.
I would very much like that. Yes, senang sekali bisa berbicara
Oh,
dengan Anda
Thank
hari
you.
ini. Terima kasih.
Yeah, and Prof. Sipan, if you have a time next year, we can arrange the lecture and other activities for coming in Makassar there physically, and then probably there are some activities you can do here with some college we have, and this would be great not only for the faculty also, but also for the university. That's all I would like to provide my appreciation. Thank you.
Thank you.
Especially our university vision and mission is to be the maritime continent in Indonesia. And the rector is also a distinguished professor in marine ecology. So he'll be very happy to meet you as well. If you can come here.
I would love to.
Yeah.
I would love to.
We are waiting for that, Professor. All right. Once again, thank you very much, Prof. Stevens, for giving a lecture for us this morning, and also for all the students and participants. Thank you very much. We will see you in the next our guest lecture. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Goodbye,
Thank you,
everyone.
Prof.
Thank you.
Stephen.
Terima
Thank you
kasih.
also, Alip. Yeah, thank you.